Queridos colegas puertorriqueños, dear colleagues from around the world, my name is Naivishikov Barreda, and on behalf of the Quebec Chambre of Notaries, I would like to thank the opportunity to contribute to the second edition of the Dialogue between Legal Systems, which is taking place in the beautiful city of San Juan, Puerto Rico. In this video, I will give a general overview of Quebec's legal system by focusing on three key aspects: advisoryalism in Canada, the interaction between the common law and the civil law traditions in our jurisdiction, Quebec, and the division of roles between lawyers and notaries in Canada and Quebec. This presentation is also intended to set the stage for the second part of the conference, which will be devoted to the discussion on the role of notaries, judges, and lawyers in common law and civil law jurisdictions. This title makes a perfect transition to my first point: to which legal family does Canada and Quebec in particular belong? Canada is a bijural country in which two legal traditions coexist: the civil law in the Quebec province and the common law in the rest of the country. According to comparative law experts, Quebec is often regarded as a mixed jurisdiction because of the combination of both legal traditions. However, if we focus on the regulation of private law relationships, Quebec's legal system belongs to the civil law tradition, which stems from pre-revolutionary French law. However, the surrounding common law context in which it has evolved has given it distinctive features within the civil law system. Bordered to the west by the rest of the Canadian provinces and territories, which follow the common law system, and to the south by the United States, Quebec stands as an example of resilience of the civil law tradition in North America. It is undeniable that several common law elements have significantly influenced Quebec's legal system. On the one hand, Canada's federal parliament has jurisdiction over important private law matters such as marriage and divorce, and that gives rise to a uniform federal private law applicable across the country in these areas. On the other hand, several institutions rooted in common law has been imported into the Quebec system, including absolute freedom of testation, class actions, punitive damages, non-possessory hypothecs on movable property, and the well-known institution of trust. Despite these multiple influences, the notarial institution remains, along with the codification of Quebec's private law, one of the most defining features of the province's civil law tradition. And this brings us to the role of notaries and lawyers in Quebec. As in any other civil law jurisdiction, the legal profession in Quebec is divided into two groups: advocates and notaries. I will use the term advocates to designate members of the Quebec Bar, according to the terminology employed by the law regulating this profession. Advocates are authorized to practice law in general, with the exception that they cannot confer authenticity on legal acts. By contrast, notaries have the legal authority to authenticate their acts, but are prohibited from pleading or representing clients in contentious matters before the courts. Let's take a closer look at the role assigned to notaries by the Quebec legislature. As public officers, they are bound by a number of obligations, such as giving impartial legal advice, asserting the capacity, the identity, and the free will of the parties, and keeping record of the documents they draft. Authentic documents are given the highest evidentiary value in civil proceedings, only refutable by way of improbation, which is a special procedure in which the party seeking to contest the authenticity of the document must prove the forgery of the act. A notarial act thus benefits from a presumption of accuracy and validity, and it proves against everybody the veracity of the facts and statements it contains. However, the Quebec notariate has some characteristics that differentiate it from other civil law jurisdictions. For example, state authorities exercise no control over notarial practice. Quebec notaries are not appointed by the state. Instead, they receive their commission from their professional body, which is the Quebec Chambre of Notaries. Quebec doesn't follow the numerus clausus rule, which in other jurisdictions limits the number of notaries available in proportion to the population they serve. And another thing is the notarial fees in Quebec are not regulated. While the distinct roles of notaries and lawyers are well defined in the respective professional regulations, bijurism in Canada has shaped the interaction between these two legal professions. A few historical remarks will help us to put this question in context. The notarial profession is one of the oldest professions in Canada, with the first notary dating back to 1647, It is interesting to note that under the French regime, which ran from 1608 to 1763, there were no attorneys in Quebec. In 1618, Samuel de Champlain, founder and first governor of Quebec, asked the King of France that justice be rendered in the colony without attorneys or prosecutors, and his request was granted. But in 1763, the Treaty of Paris was signed and Quebec became a territory of the British Crown. It was under English domination that the title of attorney, lawyer, was officially recognized, marking the beginning of the division of the legal profession in Quebec into two branches since 1765. French civil law, and in particular the custom of Paris enforced in Quebec before the British conquest, was temporarily abolished and reinstated in 1774, which officially meant the notaries could continue practicing their profession under the civil law system. In the rest of the country, dominated by the common law, there weren't and there are not two distinct legal professions, but a single legal professional, the lawyer. In most Canadian provinces, lawyers can also certify their clients' signatures on documents, a function which is called notarization. This process is primarily administrative and doesn't involve legal advice, so it can also be performed by individuals without legal training. These persons are appointed either by public or semi-public bodies to authenticate signatures, witness oaths, and certify true copies of documents, and they are called notaries public. The translation of the French word notaire into the English word notary often causes confusion among English-speaking Canadians who tend to associate Quebec notaries with notaries, public in other provinces and some other common law jurisdictions. We can say that this confusion is a side effect of bijuralism in Canada that has an impact on how Quebec notaries are perceived not only by the general public outside Quebec, but also by common law practitioners. To illustrate the point, allow me to mention that in a recent report published by the Federal Department of Justice Canada, Quebec notaries are compared to paralegals who can perform more extensive functions than paralegals from other Canadian provinces, but still cannot be assimilated to lawyers. In Canada, paralegals are legal service providers but remain non-lawyer service providers who don't need a law degree from an institution of higher education to exercise their activities. As we can see, this terminological issue ultimately raises a question of identity. Who is the Quebec notary within the Canadian legal environment? It is against the backdrop of this misconception that we can understand the inclusion in the Notarial Act of a definition of the notary as both a public officer and a legal advisor. Over the time, however, the legal advisor's role has been progressively detached from the public officer status, which is primarily associated with the function of authentication and the principle of impartiality. The dual role of notaries in Quebec has been formalized since the adoption of the Third Notarial Act in 2000, and the recent reform in 2023 has further emphasized the dividing line between these two functions. In Article 10 of the Act, the notary is described as a legal advisor, while in paragraph 2 they are recognized as public officers. As legal advisors, notaries are granted the right to represent individuals in non-contentious proceedings. These functions are not exclusive but concurrent with those attributed to lawyers, members of the Quebec Bar. Notaries can also be employed as legal advisors in both the private and public sectors. Additionally, they may apply for a Canadian legal advisor certificate, which allows them to practice law in other Canadian provinces under certain conditions. Notaries who practice as public officers are referred to as notaries working in traditional practice. They perform the typical functions of Latin notaries, which include acting as justice collaborators in some non-contentious proceedings. The traditional scope of notarial services covers real estate deeds, such as contracts of sale, mortgages, donations, and the declaration of ownerships. In succession matters, for example, including authentic wills, the renunciation of inheritance, and the settlement of estates. Another important area in which notaries have a strong presence is family law, by solemnizing marriages, drafting marriage contracts, surrogacy agreements, and other acts relating to family matters. While the significance of notarial functions has been increasingly acknowledged by Quebec legislators, Certain inconsistencies still reveal the mixed nature of the Quebec legal system. For instance, some important legal acts can be performed either through a notarial act or by a private document signed in the presence of two witnesses. This applies to acts such as the protection mandate in case of incapacity, pronunciation of parentage by a surrogate mother, and advance medical directives in case of incapacity, among others. I think that equating private documents with authentic instruments reflects a failure by the legislator to fully recognize the added value of notarial acts in these particular areas, which proves that the battle for the defense of the notary profession has not come to an end. I hope that the example of Quebec has shown the need for greater dialogue between legal systems and how such dialogue can enhance our understanding of the roles of notaries and lawyers on a global scale. This is particularly relevant in jurisdictions like Quebec and Puerto Rico, where the interaction between these two professions is not only a matter of protecting the scope of their respective competences, but also a question of preserving the unique identity of the civil law notary within a prevailing common law legal landscape. Thank you very much for your attention, and I wish you a successful continuation of the conference in the beautiful city of San Juan, Puerto Rico.